Services program. We are an enforcement program that helps carry out the California seed law. And so it is the intent of the California seed law to enable the seed industry with the aid of the state to ensure that seed purchased by the consumer buyer is properly identified and of the quality and amount represented on the tag or label. Our program helps regulate the marketing of seeds so that the quality information is accessible and accurate. We help test for seed purity and germination through sampling. We investigate seed complaints and attempt to resolve buyer-seller disputes through mediation, and then work to prevent the transmission of noxious weed seeds through seed products, and also support seed research. So our legal authority really depends on where you're selling the seed. So if you're selling seed within California, you have to follow the laws and regulations of the California seed law. And it is composed of the California Food and Ag Code, which is enacted by legislature, and the California Code of Regulations, which is enacted by the department. And then there might be some of you who have really unique seed kinds, so I would definitely recommend reviewing Section 3899 of the California Code of Regulations for the list of regulated agricultural and vegetable seed. And then the other thing to keep in mind is that flower seed is not regulated, as well as certain native grass seed. And then some common examples of regulated agricultural seed kinds are wheat, flax, annual ryegrass, and more recently hemp. And then some examples of regulated vegetable seed kinds are sweet basil, thyme, tomatoes, peppers, and watermelons. And there's also quite a few herbs that are on that list as well. And then the other thing is that if you're selling seed outside of California, so to other states in the US, you have to follow the rules of the Federal Seed Act. And that's composed of the United States Code and then the Code of Federal Regulations. And then again, if you have some really unique seed kinds, I would definitely recommend reviewing the Section 201.2 of the Code of Federal Regulations for the list of regulated kinds. And so in addition to following the Federal Seed Act, you also need to follow the applicable seed laws and regulations of the destination state. So if you're based in California and you're selling to other states like Oregon or Florida, please verify that your label complies with those laws and regulations of those states. And so our program is governed also by the Seed Advisory Board, and they shall be advisory and may make recommendations to the Secretary regarding the scope of the Seed Services Program and recommend the appropriate levels of industry funding. And then the board is composed of 11 members from across the seed industry, including labelers, sellers, and members of the public. And then our meetings are held biannually and are open to the public. And then those meeting dates and times are posted publicly on the website, much like the one you see on the right side of the screen. So if you're ever interested in joining us in person or virtually, depending on changes, you're more than welcome to come. So moving on to registration. So anyone that wants to sell seed in California has to apply annually to sell seed. And that application is always available on the Seed Services Program website. And so there might be some of you who renew your licenses every year. You often receive a courtesy renewal package in the mail, letting you know it's that time of year again. And just in case you don't receive it, please keep in mind that the application is always available on our website. Also, the application is required for sellers and labelers unless the seller holds a nursery license. And then there is a flat registration fee of $40. And then for those of you who might be labelers, there is an assessment fee of 30 cents per $100 of seeds sold in California during the previous fiscal year. I would also recommend when you check out our website and download that application, there's some more information about some exemptions for paying the assessment fee and some exemptions for the application as well. I would definitely take a look at that to see if you meet those exemptions, and that in some of those cases you might not have to apply and you might not have to pay assessment fees. Regardless, the application must be postmarked by July 31st. Otherwise, the application is considered late. And unfortunately, all these laws and regulations are already in writing, and so we cannot waive any late fees. And so if we do receive any applications late, those late fees will also have to be included in that application package. So some key distinctions between a labeler and a seller. A labeler is the person whose name and address appears on the label, and they're legally responsible for that information on the label as well as the seed. A seller is someone who simply sells and or distributes seed, and their name and address does not appear on the label. Something I do come across from time to time is that if you are a seed dealer selling to other seed dealers, you are still considered a seller. It doesn't necessarily mean that you're selling only to the end consumer or to the in-home gardener. Also, a seller may become a labeler when they do anything that requires a change in lot, such as seed conditioning, coating, or priming, or they over-label the previous labeler, or they repackage the seed. So moving on to non-commercial seed sharing activity, which might be of interest to some of you. So by definition, it is defined as receiving or giving away of seed by a non-commercial entity without the creation of a contractual obligation or an expectation to receive anything of value in return. And so with that in mind, you have to consider our definition, or the legal definition of sell, which includes for offer for sale, expose for sale, possess for sale, exchange, barter, or trade. So it's really important to keep that definition of sell in mind when you're engaging in these activities. Also, it does not prohibit a non-commercial entity from sharing seeds so long as it does not violate the Federal Plant Variety Protection Act, and it does not include receiving, storing, or distributing patented seed. And then the labeling of seed does not apply to seed distributed or received by non-commercial seed sharing activity, although we always encourage everyone to include, as much information as you would like. It would be better in some cases. Also, so moving on to labeling, I just wanted to point out some really quick general labeling rules. One is that all labels must be in a conspicuous place, clearly written and printed in the English language. You can have as many languages on the labels as you want, so long as English is one of them. And then the key difference between agricultural and vegetable seed is that those labels differ by use, container size, and germination. And then I kind of touched briefly on this, but I would definitely review some exemptions to the labeling of seeds in section 52451 of the Food and Ag Code. And again, non-commercial seed sharing was one of those exemptions. So moving on to agricultural seed, the key difference is that determining the use of the seed, so whether or not it's going to be destined for farm use or non-farm use. And so if the seed will be used for farm use, then you need the mediation notice on the label. And then if it's going to be used for non-farm use, then it needs to have a viability assurance statement. But regardless, both labels need to have the labeler name and address, the lot number, the name of kind and variety, or kind and type for each component over 5%, the germination percent and test date for each named component, the percent by weight for each named component, the percent by weight of inert matter, other ag seed, weed seed, and then the name and approximate number per pound of each kind of restricted noxious weed seed. And then some other federal requirements to keep in mind is the inclusion of origin on the label. So that would be like California or Montana or North Dakota. And then the year and month an inoculant is no longer effective, if applicable. And then some varietal names are required for certain agricultural seed kinds, or the words variety not stated. Now moving on to vegetable seed. It's a little more complex in my opinion. I feel like ag seed is much more straightforward, but for vegetable seed, it varies by use, container size, and a bit by germination. So again, you have that distinction between farm use and non-farm use. And so the label for farm use needs to include the mediation notice, and then the non-farm use needs to have viability assurance statement on the label, but both would need to have the labeler name and address. And then especially for vegetable seed, you must have the name of kind and variety. Agricultural seed, you do not necessarily need to have that, but with vegetable seed, it's an absolute requirement. Now, if you do not know the variety name, then you may state on the label variety unknown or variety not stated. Also, if you're selling in containers over a ½ pound, the lot number and germination test date need to be included on the label. And then the peculiar thing about vegetable seed is that we actually don't require the germination percent on the label because it's assumed that most of the vegetable seed kinds meet those minimum germination standards established in the California Code of Regulations. But if you choose to sell seed knowingly below those minimum standards, you can do so, but you just need to put on your label the words below standard and also include percent germination and test date. And then some federal requirements to keep in mind is that for containers over 1 pound, that you need to include the germination percent, as well as the names and rate of occurrence of noxious weed seeds. And the latter is actually a more recent addition to the federal requirements. So you might be wondering what the mediation notice is and the viability assurance statement. The mediation notice is a statement basically saying that arbitration, mediation, or conciliation are a prerequisite to seeking legal action, and that is in the event that the seed fails to conform as labeled on or is provided on the label, and that there are certain procedures that the consumer must follow as outlined in the notice. The viability assurance statement is basically the words sell by or use before, but keep in mind that the month and year in the statement shall not exceed the 15-month retail time period that is allowed. And then for vegetable seed in containers over a ½ pound, the statement may read packed for year season. So more commonly, you might see packed for 2023 season as an alternative to the sell by. So moving on to the germination test windows. When the seed is being sold, shipped, delivered, and or transported to the dealer for resale, you have 8 months exclusive of the calendar month year data test. And then for seed sold at retail, it's 15 months. And then some of you might package your seed in hermetically sealed containers, and that does extend the germination window. And so in that case, seed that is sold, shipped, delivered, transported to a dealer for resale, you have 18 months. And then for seed sold at retail, you have 36 months. However, you cannot just claim that your seed is hermetically sealed. You have to specifically state on the label that the seed has been preconditioned as to moisture content. And so moving on to some other topics that you might come across on your seed labeling or you might be involved with for your seed lots is plant variety protection. PVP is typically in effect when the developer requests and receives their PVP certificate. And then that variety may only be propagated by the person and or firm that developed the variety. And it's only valid if the buyer is notified. So it's very important to include the words unauthorized propagation prohibited or words such as unauthorized seed multiplication prohibited. And then if after the certificate is issued, including the words such as US protected variety. Also, seeds of protected varieties must include the variety name to be sold. And then I will talk about it in a minute, but some types of seed that has a PVP certificate are required to be sold as a class of certified seed. So certified seed, our main designated state certification agency in California is the California Crop Improvement Association. Some of you might be involved with this or work with them for your seed lots, but in general, they are a quality assurance program that oversees the maintenance and increase of agronomic and vegetable crop seed. And they inspect the fields, the equipment, and the seed to verify that a lot meets the very strict crop certification standards. And then they also have very strict labeling standards. There are a few different classes, and that typically starts with breeder and works its way down from foundation, registered, and then certified. And then once that seed has been certified and it's ready for sale, each container of certified seed needs to have its own individual tag. And those are typically issued by CCIA. And they look a lot like the certified seed label that you see on the lower right side of your screen. There are some exceptions for those who might sell seed in large bulk quantities, more commonly seen with some grain seed. They do issue bulk sales certificate, but that's typically at the time of sale. And so moving on to some treated seed label requirements, I assume that maybe not a lot of you might have to be concerned about this, but there are a lot of label requirements. So in California, you need to include the words treated seed and then the signal word for the category of treatment, which are typically caution, danger, warning. And then the chemical and or generic name of all treatment materials. Each applied substance must be labeled, and those label hazards must be for the chemical with the highest level of toxicity. And then the information must be derived from the technical label of treatment chemicals, as well as an appropriately worded statement as to hazards to humans and animals, an appropriately worded statement of practical treatment if present. And then some federal requirements to keep in mind for certain categories of chemical treatments. The label needs to include the appropriate caution statement, such as do not use for food or feed or oil purposes, as well as this seed has been treated with poison in red lettering, and then the pictogram of the skull and crossbones. So it is a little bit more complex. Moving on to some additional regulations to keep in mind. For those that may token label, that's typically if you have a pallet of seed that you're going to sell to a customer and you put one label on the pallet of seed that represents that particular lot. And that's okay. However, it is not permitted for treated and or certified seed lots. Also, prohibited noxious weed seeds are not allowed, and that the list of prohibited noxious weed seeds and the list of restricted noxious weed seeds are available on the California Code of Regulations. And then for those of you who might sell to other states in California, I would definitely verify that any weed seeds that you find in your lot or come out through your analysis testing, that you verify that that weed seed doesn't appear on an all state list or isn't categorized as a prohibited or restricted noxious weed seed in other states, because it does vary a little bit. Also, the lots cannot contain over 1.5% by weight of all weed seeds. And so with seed disputes, I hope no one ever has to go through it, but in the event seed does not perform as reported on the label, a consumer may pursue alternative dispute resolution. And in California, mediation is a prerequisite to seeking legal action. We do not use arbitration or conciliation for seed disputes. Also, all parties must participate in the mandatory dispute resolution process as outlined in the mediation notice, which again is the paragraph that you see on the right side of your screen. So it's really important that you add that to your labels for seed being sold for farm use. And then in the event a seed dispute does happen, the person alleging damage must file a written complaint with a $250 filing fee with the California Department of Food and Ag within a reasonable time frame. And then typically it starts from complaint, proceeds to a CDFA investigation. There is a report of our findings, and then it goes through the mediation process. And then once that seed complaint process is complete, the parties may pursue other legal remedies. And so my last slide is just going to talk about record keeping. And so we wanted to remind everyone that the Federal Seed Act does require 3 years of complete records for seed lots. And that includes, but is not limited to, receiving records, variety and origin, and grower's declaration, processing and handling, conditioning and blending, test record, file samples, labeling records, sales and shipping and distribution records, and correspondence. So with that, I would like to thank everyone for listening today. If you ever have any questions, please feel free to email us at seedservices@cdfa.ca.gov. Our phone number is also posted here. And then there's a link to our program website, as well as a link to the Federal Seed Act, should you ever have a moment and want to review the laws and regulations. Also, there are 3 inspectors across the state of California, myself included. I'm based out of the Sacramento area. And then there's also an inspector in the Central District based out of Fresno, and then an inspector for the Southern District based out of the Palm Desert area. So with that, I'd like to open it up if there are any questions.